This is the current federal tax developments for the week of July 20th, 2026. Current federal tax developments are brought to you by your state society of CPAs, and we're coming this week again here from Arizona, trying a little bit of a different layout structure and having a little bit of fun with my external monitor, so I'm having to record this on the internal. So it's a little bit different this week, and unfortunately, the internals on this particular MacBook Pro are not the same as the standard 1920 by 1080s. So you may have a little bit of weird size. You're watching this on the video, but hopefully it'll all work out. So we have a few things going on this week. We're going to talk about a number of developments. We're going to start this week looking at an IRS ruling. This was internal, but discussion of the partnership issue with economic risk of loss under Regulation 1.752-1. And this deals with a case about a deficit restoration obligation. Now, general rule here, we're going to talk about here, we have a partnership or an LLC, and we're looking at a case of, does the deficit restoration obligation end up meaning that we can treat the debts as recourse? And what are the requirements for that to be true? Now, generally, recourse liabilities defined in the regulations tell us that a partnership liability is recourse only to the extent a partner or a related person bears a true economic risk of loss. EROL is the way it tends to be written. And a partner bears this risk of loss if they are obligated to make a payment or contribution in a constructive liquidation of the partnership. That is, if in fact we go through this whole blow up the partnership routine, we figure out all assets are worthless unless they're secured by a recourse debt, unless they secure recourse debt. And then we just kind of, work on that theory to allocate out the recourse debts and figure out, who would end up writing the check. So that constructive liquidation test assumes all liabilities become due and payable now. No reimbursement is, basically you're not entitled to be reimbursed by any other party, would be the based on this issue. It's only for that part of the debt. Now, there is a facts and circumstances standard found in the regulations under 1.752-2 B3I. And this economic risk of loss determination is based on the facts and circumstances at the time of determination. And to take this into account, it means that all statutory and contractual obligations, not congressional, contractual obligations had to be taken into account, and very specifically, those you're going to find in the partnership or operating agreement. Obligations include capital contributions and obligations to restore deficit capital accounts upon liquidation. We're seeing if you would have to write a check. That's what we're really looking at here. Now, this is now looking here at Chief Counsel Advice 2026-28009. And this is a question about a general partner's discretionary demand power. Is that enough to make the limited partner's liability to, basically to be an economic risk of loss? And under the partnership agreement in this Chief Counsel Advice, limited partners are generally shielded from general liability. That's a normal case for a limited partner. But if a limited partner has a deficit capital account balance, the general partner has the discretion to demand a cash contribution. Okay, now notice that word discretion is going to become important here. If limited partner fails to comply, then the general partner may, again, not mandatory, withhold future distributions up to the deficit amount. But the problem is there's no obligation here. They just may do it. And crucially, the partnership agreement provides no further recourse for a failure to restore a deficit balance. And notably, the agreement does not require the limited partner to restore a deficit capital account upon liquidation of the partnership. Now, the question being posed here was, hey, is this limited partner, because they could be asked, if in fact their capital account went negative, if in fact, if everything went worthless, we could assume it would go negative. If it went negative, do they have economic risk of loss? That's the key question here. And so what this Chief Counsel Advice came back on was told us that to be valid as a deficit restoration obligation, which will count to allow us to take this into account, obligation must satisfy both 1.704 B2 IIB3, or I should say either, or 1.704-1B2 IIC1. A partner must be unconditionally obligated to restore the deficit balance of the partnership. That restoration must occur by the end of a taxable year, or if later, 90 days after the date of partnership liquidation. Because limited partner's obligation in this case is contingent on the general partner's demand, it fails the unconditional standard. And the lack of a liquidation contribution requirement further violates the fundamental economic effect rules. This is not going to be recourse debt. In essence, they're not going to have a right to be allocated recourse debt. While they could be held liable for it, it's only going to happen if the general partner actually says, "Hey, make this up." And and if we don't have an actual debt, first thing is you got to have an actual, negative capital account, and secondly, that in that case, general partner still has to say, "Hey, you give me a check." Don't say that; you're not required. That's not going to work for you. So, the Chief Counsel Advice 2026-28009 concludes that conditional obligations do not shift the risk of loss. Because limited partner's obligation is conditional rather than unconditional, it does not meet the criteria for a deficit restoration obligation. A limited partner's conditional obligation is not a payment obligation under the regulations that govern this for Reg 1.752-2B. Therefore, the limited partner does not bear the economic risk of loss for any partnership recourse liability until such time as they get told pay up. Now, drafting tips in this case, if you want to make sure that limited partner is going to get allocated the recourse debt. Now realize this has non-tax impacts too, so let's be very careful here. But understand that if you're going to use discretionary non-binding clauses, you're not going to be able to shift recourse debt basis. Right? It's got to be mandatory. To shift that, the deficit restoration provisions in the partnership agreement must be mandatory, legally binding, and automatically triggered on liquidation. Now, the hitch with that is obviously that has consequences beyond the tax consequence, right? It's a very different world if I might be asked to put money in than if I absolutely have to put the money in, right? That's going to be it. Again, presumably they were looking at an actual situation in this case where somebody had this drafted. Again, it'd be a weird agreement. And you're almost thinking that's got to be related parties in some way, shape, or form, just because, you have to have a pretty good idea, probably limited partner has a good idea, that they'll never actually be asked to do it. That's going to be the assumption of effectively the reg. Now, you might have noticed fuel prices have been going up and down. In fact, I was just out today and noticed that the prices have gone back up again on the pumps of the two stations that I passed closest here and around the valley because I was out and about today here in Phoenix. They went up, then they went down. Now they're going back up, right? We're bouncing around. Well, this is going to be another one of those years where we're going to have two different standard mileage rates. Announcement 2026-11 that was published on July 10th of 2026 is a formal modification to the notice 2026-10 that began the year. Now, the reason they made this adjustment is the shifting economic conditions, and per the announcement, the recent increases in the price of fuel. The adjustment aims to maintain the integrity of the standard mileage rate system, ensuring that it reflects actual business operating costs for the vehicle. These rates are utilized for computing deductible automotive operating costs and determining substantiated reimbursement amounts under your employer plan. Right? So effective July 1st, the revised optional standard mileage rate for business use and automobile is now going to go to 76 cents per mile, up a couple of cents from what we had earlier in the year. Now, again, this rate applies to deductible transportation expenses paid or incurred for business purposes on or after July 1st, 2026, and also for employer reimbursement. The revised rate applies to mileage allowances paid to employees on or after July 1st. These expenses must have been paid or incurred by the employee on or after July 1st. So basically, if you just haven't reimbursed them for June, you can't go back and increase that, right? And the previous rates are applicable for any expenses paid or incurred before July 1st of 26. So again, it's going to be one of those split years. That always causes a little bit of interesting angst when you ask a client, okay, how many miles did you drive for business this year? Okay, and they say, and you're going to ask them, because you do, because they have to have this, do you have contemporaneous records, right? Are those records written, etc., all that stuff. Now, the problem is we're generally allowed to accept their answers unless we have reasons to believe they might not be correct. Then we have to kind of ask for, can I see it? If they come in and they say, oh, I drove 12,320 miles, and you're like, okay, how much of that was before June 30 and how much was after? Now, in theory, if they actually have a record that has all the things, the date, the date they drove, where they drove, etc., all that stuff. In theory, it might be a pain to go back and rerun the tapes, right, for them, or go back and add them up. Most people don't have tapes anymore on their adding machine. So go back and re-add that up. But in theory, they should have it for each. And while it is possible it could be exactly the same for the first 6 months and second 6 months, it's highly unlikely. So unfortunately, you have to tell the client, if you tell me to split it in half, that's going to be kind of an indication you don't have logs. And and if we do that, I'm not being the IRS, but I'm going to tell you that an agent will probably consider that a bit of a flag that you don't have the records, and so might very well get them much more interested in asking for details of those records. So you might want to figure out the real numbers. Just saying. Now, this only changes the business mileage. Medical and moving rates, well, I should say medical and moving rates, they do rise to 23.5 cents. And while the charitable rate remains fixed at 14 cents. So business rate, 76, medical and moving, 23.5, charitable rate, 14 cents, right? All of these things, because that's fixed per the code. Okay, also this week, the IRS announced some modifications to the business tax account. The claim of the services is going to make it into a comprehensive self-service portal. Now, again, they've transitioned the business tax account from a limited pilot to a comprehensive platform, saying we're now rolling the real thing out. These BTA, business tax accounts, are a comprehensive role-based service portal, self-service portal, that alters how practitioners manage compliance, remittances, and verifications. And these parameters are detailed in a fact sheet that was issued this week on July 9th, fact sheet 2026-11, and the official platform documentation on the web. These expansions are designed to reduce paper-based workflows, improve the taxpayer's experience, and secure cloud centralized account management. We've talked about these before and how they work and how a business goes about setting one up. Now, some of these enhancements. Number one, practitioners and authorized users, you want to check the setup here, the details of the BTA accounts and setting them up, because it will tell you who is authorized to set one up for various entities. And what we and the authorized users can do is gain access to digital notice libraries, and they're going to add CP8080, CP081B, CP211 Cap A, and CP134R, more notices. Designated individuals can download notice CP575 directly, replacing traditional letter 147C for banking and loan requirements. So you can just get that on the web automatically. And there's office and compromise remittances. Eligible taxpayers may submit payments toward an offer in compromise directly through this secure digital BTA portal. Okay, that's there. And then there are 5 standardized modules to replace and simplify compliance tracking. First is the profile and balance. One is in profile and balance. Profile is to view and verify entity name, address, and manage user permissions for the account. Balance views total amount owed with a year-by-year breakdown. For payments and history, we're able to make payments and deposits and schedule up to 12 months in advance or cancel scheduled transactions. We can look at our payment history, track wire, EFTPS, check or money order payments. On records and letters, we can request compliance checks, view transcripts for payroll, income, and excise taxes. And for as far as letters, we can read notices, accept and reject the IVES transcript requests lenders will ask for. So you can do that as well on this new improved structure. Now, there are some strict identity checks, and there's an annual renewal requirement for these programs. So this is meant to secure access, so people can't get access to data, or people who have left the company are not going to be still on the account. The access follows a strict two-step security protocol that's aligned with the Internal Revenue Code section 6103 confidentiality requirements. The first step is identity verification. That's performed by using the IRS's third-party identity verification provider, ID.me or the Gov, what is it, ID Gov, whatever the second one is. Step number 2 is a role authorization. It validates the relationship of the person applying to the entity and assigns either limited or full access tiers. And the BTA utilizes the same login credentials as the individual online account. So if the person trying to get access has an individual IRS account, you just can use those same ID.me credentials to access this. You still got to prove, role authorization is still required, but the identity verification step may have already been completed by people that have set up such an account. Now, the annual designated official renewal window occurs. These are designated officials for S corporations and C corporations have to renew their access annually. The renewal window is strictly limited to a 6-week period between June 15th and July 29th. So keep your eyes open for that. Failure to renew during this designated window requires a complete manual re-registration process. And the officials must remain active officers, maintain current W-2 employment, and retain legal binding authority. So if you set up yourself last year and it's a corporation, right, or it's an LLC pretending to be an S corporation or a C corporation, remember that you need to get in and the designated officials need to go in and renew their access. Otherwise, they're going to be redoing everything, which is going to require the role authorization again, and getting letters mailed and all that other stuff. So probably you want to make sure you get that done. If in fact they do, they're still active officers, they have W-2 employment and retain the authority to bind the entity, you'd want them to just go in and renew. Okay, we have a case here this week about a taxpayer who discovers that proceeds from a lawsuit can end up costing you more tax than you net make under the law. This is Eiler versus Commissioner. This is a reported tax court opinion, 167 TC number 3. The opinion was issued on July 14, 2026. Now, the issue addressed, and it is an issue of first impression, is whether fees incurred to settle Fair Credit Reporting Act claims qualify for an above-the-line deduction. So we're looking here about a FCRA, claim under the law, and you can go for damages under that. And a taxpayer who did it under a contingent fee arrangement, right? And that's where the key problem comes. Because if it's like most legal expenses, that are going to be maybe incurred for the production of income, which is what this is considered, generally, unless you qualify for one of the exceptions, you're going to have a problem because that's going to be a miscellaneous itemized deduction that's currently totally non-deductible. And therefore, it is very possible if, in fact, the contingent fees eat up most of the award, which they will do in this case, that the taxpayer is going to owe tax on the entire award, no deduction for legal fees, which means they're going to owe more tax than the money they got, for actually were able to keep net for the claim. Now, Section 62A20 is one of those sections that allows a netting. And that allows an above-the-line deduction for attorney's fees paid in connection with unlawful discrimination claims. Now, the problem is they have to involve civil rights, and the tax court analyzed the meaning of the term civil rights. And they held that claims involving credit report inaccuracies do not involve civil rights as contemplated under Section 62E18I, which is also related to this. And so consequently, the taxpayer's attorney's fees were deemed to be fully taxable and non-deductible above the line. And of course, because they're an individual, miscellaneous itemized deductions, you're not getting it below the line either in that case. Now, they did go back down the line. What about anticipatory assignment of income rules? And this goes back to the 2005 Supreme Court decision of Commissioner v. Banks, 56 U.S. 426. And that was actually the decision that led to the special rule for those, certain claims like civil rights claims to allow you to claim the deduction. Because under Banks, the Supreme Court generally ruled a taxpayer cannot exclude economic gain by assigning it in advance to the legal counsel. Now, the IOLers argued their legal agreement recovering statutory damages and various actual percentages was not a standard contingency. And it was weird, their structure. You can read about in the case. Now, Judge Geider in this case rejected this view. He said a contingent fee simply is a fee charged only if the lawsuit is successful or settled. And this was true. Under their agreement, the law firms would get nothing, right, if the lawsuit, was not successful or there wasn't a settlement paid. And because recovery was contingent on settlement, the entire settlement proceeds are gross income to the taxpayers. And again, it was not a good result in this case. What happened was the taxpayers netted only $4,700 of a $64,750 settlement, as fee-shifting arguments were rejected. No above the line, and you can't argue that, yes, the law firm is going to pay tax on the law firms in this case, I think there were three of them. They're going to pay taxes on the $60,050 that they received as, legal fees, but taxpayer, that $64,750 was awarded to you by the court, and you paid legal fees of $60,050. And the problem is that $64,750 is truly taxable to you, that was reported to you on a 1099, despite the fact you only got a pocket, in this case, $4,700. It's like, not good. Okay. And like we said, why did civil rights not work? Well, the plain meaning of civil rights, as defined in the IRC section 62, is what the court looked for. It's trying to find out what is it. It says, well, it's undefined, so we're looking for the plain meaning. So it used standard statutory construction based on its 2004 meaning. It went to Black's Law Dictionary, a favorite place that lawyers and courts like to turn for such terms that have legal that are used quite often in legal context. And it says restricts civil rights to equal protection, due process, and voting rights. Fairness and accuracy in credit reporting represent consumer protections, not constitutional liberties. And the Equal Credit Opportunity Act explicitly bars discrimination, which would be a civil rights action, but this is under the Fair Credit Reporting Act. That has no such provisions related to discriminatory, credit reporting. Now, so talking about the specific provisions they pled, Section 62E18 requires evaluating the specific statutory provisions actually pleaded in the underlying complaint. They pleaded violations of 15 U.S.C., Title 15 United States Code, Section 1681EB, 1681G, 1681I, subsection A, and 1681S-2, subsection B. These specific sections are designed to protect fair and accurate credit reporting, not consumer privacy. Because the Eilers failed actual privacy provisions under sections 1681B or 1681Q, a privacy-centric construction, which might be able to get you civil rights, failed. They weren't claiming that was where the problem was. Okay. So this is something we need to work with with clients and attorneys when we have complaints and settlements. When in the pleading specific outcome, you need to have a discussion. If a client's going to be going to court on something, they may want to bring you in and discuss with their trial attorney, with the attorney that's going to draft the complaint, about the importance of how that's drafted if they're going to go for a better tax result. You want to plead privacy, confidentiality provisions to restore a possible civil right argument under this type of case. But in any case, you need to be careful, right? Even if it's not this directly, you have to make sure the right things. And the problem is litigators like to do what I call shotgun, right? Kind of the shotgun complaint. We swear everything awful in the world ever that they might get award damages for, the defendant did. The problem with the shotgun, especially if we don't get basically a settlement or an award that specifies exactly which one of those things we're getting damages for, it's going to be taxable and without the deduction. So, following the Tax Cuts and Jobs Act of 2017, miscellaneous itemized deductions, which includes any legal fees that are not related to a trade or business, right, even if they're for the production of income, so 212 legal fees, they were suspended through 2025, and we know the One Big Beautiful Bill Act has now made that permanent. So, failing to qualify under the Section 62 provisions for legal fees, it's going to result in a zero tax deduction for an individual. So, that's going to force the client to pay tax on funds that the attorneys had. Right? Now, and the other catch, as I mentioned, silent settlements is the term that's used here. A silently drafted settlement agreements are presumed fully taxable to the plaintiff under Holiday versus Commissioner. Silent means they didn't say what. They didn't specifically allocate the settlement. In a settlement agreement, we would like to see it allocated to potentially non-taxable items. Now, the defendant is probably going to want to say, no, this covers all of your complaints. You can't bring anything else about the court. We're not going to simply say it only settles this thing. All others are settled for zero or whatever you're going to do, but you have to be specific. And again, normally the first thing is a litigator, on your client's side just looks at this is done. And potentially trying to demand specific statements could get some pushback from the plaintiff, again, extending the time frame to get this drafted, potentially increasing the legal fees, or maybe kill the settlement entirely. So it's always kind of funny. So while we would love to have, we need to tell people, make sure that everyone is aware that if these allocations in the settlement agreement aren't precise and tell us exactly what it goes to, there's a good chance that, Mr. Attorney, your client may need to pay taxes on what you're getting paid on this contingent fee structure, right? Or just fees general. Basically, if you write it the other way, it could either not be taxable or it could be when it fall in the cases where your fees are going to be deductible above the line. So, be very, very careful there with legal fees. The problem is clients don't really think about it if they're involved in a legal situation, get roping in their tax people, as the process goes forward. Because, that pleading can come back to hurt you. We may have anything pled that was actually going to be tax exempt. And that could lock you in badly in this case. We have another regulation validated this week, kind of related to the one we discussed last week, or a similar concept. The tax court invalidated temporary regulations, section 1.245A-5T, under the plain meaning of section 245A. This was another case involving offshore income situations. In this case, for the extraordinary disposition rules, out of this, that they put in different effective dates, which left a kind of a gap in the law that you could use to your huge advantage. And NARA's tried to shut this down with regulations. So this is Siemens Medical Solution USA versus Commissioner. Again, a published tax court decision, 167 TC number 5. And again, we're looking at temporary regulation 1.245A-5T. Now, this contained extraordinary disposition rules, which limited your access to the 100% dividend received deductions. The regulation disallowed 50% of the 2045 DRD, dividend received deduction, for dividends paid out of an extraordinary disposition account. Now, the tax court granted summary judgment for the taxpayer, holding the regulation was invalid as a matter of law. And this is a continuation of the Loper-Bright effect on statutes, a push for, following and this part actually, I think this reg had trouble even under Chevron. But, we can argue that maybe a little bit. This one appears to have a little better shot than what we discussed last week under Chevron. But this also clearly limits the IRS's rulemaking powers. Okay. Now, what's happened here, their mismatch effective dates in the Tax Cuts and Job Act create effectively a tax-free earnings and profits gap during Siemens Dutch restructuring. Now, SMS BVI, the Dutch subsidiary owned 67.78% by, SHDUS, sold Swiss and German affiliates for 1.42 billion euros, growing E&P by 819 million euros. So that was the Dutch sales, the first thing. Now, SMS's BVI's disqualified period from January 1st to September 30, 2018 arose because Section 965's MRT and 951 decap A's guilty had different starting boundaries. It left a gap. Because the restructured EMP fell into the gap, it was not subject to either regime. Yet it was literally eligible for the 100% dividend received deduction. So it's like it just never. Nothing happened. It was totally non-taxable. Fell into that gap. Now, the IRS issued the temporary rate in question to prevent taxpayers from exploiting its effective date. So it said, if you do this, we're going to disallow half of the dividend received deductions on dividend paid out of extraordinary disposition accounts. This situation. So the IRS issued notice of deficiency to Siemens, disallowing $314,992,962, say $315 million, of its claim Section 245A deduction. The IRS argued the rule was valid under Section 245 Cap A subsection G, which gives the IRS the right to write necessary or appropriate rules, and the broad grant of authority under 7805 subsection A that they can do needful rules for, the code as a whole. Now, as we discussed last week, we already had a ruling from a Circuit Court of Appeals that said, no, you can't stretch 7805 to cover everything. But in this case, at least the section itself had references that would theoretically have applied to the subsections they were dealing with. But the tax court held the regulation was a unilateral attempt by Treasury to correct a mismatch that was created by Congress, literally in their wording, right? So, the unambiguous statutory text must prevail over conflicting administrative regulations. And by the way, that's pretty much even under, I would say that I think the result on that part of it is the same under Chevron as it was Loper-Bright. If the code itself gives you the answer, there's nothing for the IRS to interpret. Now, the statute for 245 Cap A allows 100% dividend received deductions for the foreign source portion of a dividend. All statutory elements, including being paid in the year in which you begin to get that, were met in this case. And temporary regulation, though, of 1.245 Cap A-5T attempted to disallow 50% of the deduction using criteria that is absolutely nowhere in the statute. It contradicts the plain meaning of the text enacted by Congress. Congress didn't indicate there was a kind of a wishy-washy effective date. That's not in the regs or in the code. So post-Loper-Bright, which is a 2024 U.S. Supreme Court decision, reviewing courts must independently interpret statutes and figure out what's the will of Congress. Courts must fix the boundaries of delegated authority and ensure agencies engage in reasoned decision-making within those boundaries. Now, the court said the Tax Cuts and Jobs Act mismatch in the effective dates was a product of explicit policy choices made by Congress. Congress chose to adapt the distribution made after December 1st, 2017 rule for 2045A, and the courts are going to respect that choice. The IRS can't put any special rule in there. The Treasury cannot unilaterally rewrite clear statutory terms or approximate, the MRT guilty tax treatment to suit its own policy preferences. Congress knew how to write that. Writing an effective date is not something that's tough. They wrote two different clauses. It's like they know these are related sections. They wrote two different effective dates. No, IRS, we're not letting you change that. That's basically how it goes. Now, we got more ERC cases, okay? We've had these, and they keep coming. And again, they're not really being consistent, although if you're in Mississippi, we're beginning to see a nice pattern in district courts in Mississippi. Now, this is South Delta Planning and Development District filed amended Forms 941 in early 2023 to claim the employee retention credit. The IRS initially processed the amended returns and issued refunds for 4 of the 5 quarters. So quarter 2 and 3 of 2020, quarters 1 and 2 of 2021. in late 2023, the IRS reversed its position, disallowed the refunds, and assessed South Delta for the full amount of the 2020 refunds. Now, the IRS has remained silent regarding the third quarter of 2021, for which it never issued a refund, right? And, so we had that in that amount. So to challenge these assessments, South Delta paid the payroll taxes for a single employee in the disputed quarters to file a refund complaint. Okay. That's how they went off and did it. Now, the divisible tax rule permits you to do that. Usually, remember, you got to pay the tax due to sue in district court. But payroll refund suits can work that by paying the tax for a single employee. Now, the first thing, though, is we look at sovereign immunity and the prerequisites, because this is what the IRS is going to try to hide behind. Taxpayers sued against U.S. government require express statutory consent under Section 7422 of the Internal Revenue Code. Consent is strictly conditioned on three prerequisites. Payment's been made, a proper administrative claim has been filed, and the IRS disallows the claim, or we've waited 60 days and the IRS has not, basically responded to our administrative claim. Generally, the Flora full payment rule requires paying the entire assessment before bringing a refund complaint. But there is this divisible tax exception you'll see in payroll tax situation. Divisible tax rule allows the taxpayer to pay a divisible portion of the tax to test the validity of the entire assessment. Because payroll taxes are by the very nature divisible by nature based on each employee. The payment of the assessment for a single employee satisfies the payment requisite. The court validated South Delta's payment, establishing subject matter jurisdiction over the assessed periods. Okay. And the court also, again, as we talked about last week, and I don't think every court is going to reject this theory of the IRS. The IRS has attempted to claim that if they gave you the refund, then later come back and, assess the refund again. Basically says, hey, no, that was in error. Give it back to us. And you give it back to them. You still have to file yet another administrative claim or you can't sue, right? So the government said South Delta failed to file an administrative claim after reassessment. Therefore, those 4 quarters that, that basically they had received the refund and then were asked to pay back the money, that they failed to file a proper administrative claim. Because of that, they couldn't go to district court because they didn't have the ticket to get in, right? The IRS argued issuing a refund makes the taxpayer and governments all square, making any subsequent assessment a brand new issue. Now, this court, like we discussed previously, this is not the first court to reject this formalistic loophole, labeling it ineffective, time-wasting administrative exhaustion paradox. Because both parties are arguing the exact same funds claimed in the original 2023 Form 941X, the original claim remained valid. Requiring a taxpayer to file a second Form 941X for the same quarter and same credit is not, in the view of the court, required by the law to get the right to sue the government. Okay. Now, however, they could not grant declaratory or injunctive relief, right? So, because they were asking them to note things, require the IRS, to, basically repay things, require them to accept that they'd approved it. There are various things that the taxpayer is asking for. Now, the tax court has full jurisdiction over valid refund claims under 7422, where the prerequisites are met, right? But declaratory injunctive refund relief claims are barred. That's barred under Title 28 United States Code, Section 2201, and Section 7421 of the same title. Courts cannot restrain the collection or assessment of tax, which is what they were asking them to do. They were asking it. So those parts of their complaint, sorry, we can't rule on those, right? And the government again went after the shotgun pleading. And this is where we've seen a split among courts. The government argued that the complaint was an impermissible shotgun pleading for failure to match specific shutdown orders to specific quarters. We have seen courts reject it, saying, sorry, taxpayer, you didn't plead well enough because you didn't tell us which order links to which claim. It's not up to the IRS to go find out and try to read your mind. In Mississippi, apparently they're liking the mind reading, right? The court rejected this. Not really mind, but they're saying it's too early, right? Under Twombly, and the Iqbal standards. I love cases. We need people who have big cases, to like include pronunciation guides. We need that there. We don't get them though. A taxpayer is not required to make such matches at the pleading stage. It is sufficient to allege that business operations were suspended in response to governmental orders issued during the COVID-19 pandemic. Where the orders ultimately substantiate ERC eligibility is a fact-intensive issue for discovery or a summary judgment and not a motion to dismiss. So the court lifted litigation stay and allowed the remaining claims, quarter 2 2020, quarter 3 2020, and quarter 3 2021 to proceed to discovery. Okay. Now, the 11th Circuit has now, for the first time I can recall, we now have these conservation easement claims, right, with the mining. They're now going to the courts of appeals, and unfortunately, Savannah Shoals LLC versus Commissioner, case number 24-12-611, heard by the 11th Circuit, or basically opinion issued by the 11th Circuit this week. It didn't go in the taxpayer's favor, right? Savannah Shoals had claimed a $23 million charitable deduction on its 2017 return, valuing a 103-acre tract as an aggregate quarry. Now, the IRS rejected this deduction in its entirety. It valued the easement at a fraction of the claim and imposed substantial penalties, including the automatic gross valuation misstatement penalty. Now, the tax court basically valued the easement at $480,000, the pre-value $580,000, less the post-value $100,000, and sustained a 40% penalty on taxes that arose on the difference between basically a $480,000 deduction and a $23 million deduction. Be different. The 11th Circuit affirmed this case, holding that filings of fair market value are reviewed for clear errors and legal conclusions, right? Now, appraisal guidelines, the court rejected the taxpayer's view that appraisal guidelines are legally binding standards on federal courts. Rather, they held deductions for perpetual conservation easement restrictions are valued under a before and after method used based on highest and best use. Treasury Regulation 1.170 Cap A-14 subsection H3I dictates valuation is based on the fair market value at the time of the contribution. The taxpayers argued the tax court erred by failing to strictly apply for the four appraisal factors: physical, legal, financial, and maximal. The 11th Circuit flatly rejected this, holding that professional appraisal guidelines like those of the appraisal institutes do not bind courts. The regulatory focus remains the objective likelihood of the development, not a mandatory mechanical application of the four-factor test. That was found in the appraisal guidelines. They admitted that courts have mentioned that before, but saying there's no requirement to go there. Okay. Now, the real problem they have here, they found that this was, it was just basically, it was a speculative theory because it just didn't make sense that you would do this thing as an aggregate quarry due to high shipping costs and pretty active current competition already existing. First problem is the cost of shipping this stuff. Transportation costs restricted heavy aggregate market to a 50-mile radius of the quarry. It's heavy, it's expensive to move, and the transportation costs become bigger the further it goes. So it can't be competitive outside of 50 miles. It's got to be within that. Now, that surrounding area of Hart County, Georgia was primarily rural with low growth and population. Right? The taxpayers' experts erred by using statewide demand rather than saying, hey, no, look where they are. It'd be like me sitting here in Arizona, if we have this supposed highest and best use thing for developing something for whatever it might be, let's say, probably not going to be this, but the idea where it's only going to be valuable within 50 miles, the product here we're going to mine has to stay within 50 miles. If we use the state as a whole, and we're talking about something, that's in the far southeast corner of Arizona, which doesn't have a lot of population, and we're using statewide figures that would include Phoenix, yeah, there'd be a problem there. Major metropolitan areas of Greenville, Augusta, and Atlanta were too distant to be economically reachable. And once you took them out of the mix, yeah, things didn't look so good. There was also very stiff local competition, right? And the financial numbers just didn't work. Taxpayers' experts failed to account for competition from 7 active quarries that were close to the metro areas that were involved. Close to competitors pose significant delivered price advantage, over in Hart County compared to this one. Financial projections were also highly unreasonable. They're projecting a 67% profit margin, and the industry as a whole only gets 24%. Where are they getting this elevated theory that it would sell for so much more? Right? That's not what the market shows is HALPA here. Especially, this looks like, if anything, it should be a much lower gross margin. So as the court was financially unfeasible, residential development was the correct highest and best use. Therefore, this is another case of the theoretical mind. And again, these tend to be in Georgia, right? And they tend to be these sorts of things, granite mines, and similar structures, which, again, they're not faring well in court. Okay. And so what they did, to use the same day arm's length membership interest sale, triggered a 40% valuation penalty. Because here's what happened. The developer sold a 92% membership interest in Savannah Shoals LLC on the very day of the easement donation. And if you use that to value it, you determine the value of the whole property is right at about $580. So tax court used that arm length sale to pin the pre-assessment value at $580,000 and deducted the $100,000 post value, because the taxpayer is saying it's only worth $100,000 afterwards. Okay, good, we'll accept that. We're just not accepting that it's $23 million and 100 and plus 100,000 is the overall value, right? And because the $23 million claim exceeded the actual $480,000 value that was donated by over 200%, I'd say just a little bit, the 40% gross valuation penalty was sustained. Remember, this penalty has no way of getting out of it for reasonable cause. That's the big negative of this penalty. So, this week, what do we have on this week's session? Remember, we looked at the partnership broad recourse rules. Conditional deficit restoration obligations are not going to allow you to claim there's economic risk of loss to allocate non-recourse debt to the taxpayers. Remember, our mileage rate is going to 76 cents per mile effective July 1st of 26. So we're going to need split mileage again this year. We do calendar year returns, or actually any fiscal year returns, just going to be split a little differently. Business tax account. Remember, we have now had changes there. If you've not looked at that, you might want to take a look at that. There are some self-service portal features, but remember, there's active annual maintenance required for corporate, individuals who are accessing the corporate account. We had the litigation legal fees problem that I think everybody runs into from time to time. Warn your clients, if they are getting it, if they're doing litigation, doing it on a contingent fee basis, make sure that, we're going to check to see whether those can be deducted above the line or not, and whether the damages will be taxable. And that's something that all too often nobody looks at the tax issues until the client walks in during tax season. And by then it's too late to get it fixed. Okay. It's kind of got to be fixed ahead of time. It's really best if anticipated throughout the litigation. So at least everybody goes in eyes open, and counsel can, talk to the client about, why it may be disadvantageous from the total award to only ask for things that could qualify as exempt, or ask for things that could allow the deduction above the line. And the client can understand that if it's going to be totally taxable to them, and the contingent fees are going to be non-deductible, note their marginal rate they'd be in, marginal bracket, and tell them, look, you do this, you can win, and you're going to be paying money out of your own pocket. Because after you pay your attorneys, no deduction for that, you're going to owe more tax than you've got left. We also talk about the ERC litigation. Again, we're not getting consistent. This was another case, kind of interesting case in Mississippi. Not surprisingly, I guess, kind of follow the others. And like I said, the IRS is very much saying that if they came after you to get the refund back, you need to not only pay, because you still got to pay to sue the government, but you're going to have to, in this case, turn around and, essentially, you're not going to have to go around and file this additional administrative claim, but the IRS is arguing you have to. Now, if you're not comfortable that that's going to prevail across the country, which I think we should always be a little, leery of thinking it will if we have a point to fix it, you might want to file an administrative claim and then turn right around 60 days later and file the suit. Just do that so you dotted the I. And also, we talked about the conservation easement, our first appellate case I remember seeing on all of these Georgia mines. And yeah, it didn't go well for the taxpayer. So anyway, this has been Current Federal Tax Developments for this week here on July the 20th. I want to thank you for watching this week, watching or listening. Again, if our slides are available online at currentfederaltaxdevelopments.com, in the weekly audio and video update. We also have a copy of the articles in a PDF form if you want to have the articles that talk about all of these cases, give you the full citations, and additional information about these particular developments are there. As always, I am available, Ed Zollers at currentfederaltaxdevelopments.com. You want to email me there. You can also find me on the Connect sites for the Arizona Society of CPAs, New Jersey Society of CPAs, Minnesota Society, Illinois Society, and Idaho Society, and Washington Society. Keep track there. Like I said, this week we had a little bit of problem. And this week, for the first time, I did use something that's been added to, well, now it's called Gemini Notebook. But it was added to Notebook LM, and then they changed the name. It was added like last week to Notebook LM, and now it's changed the name to Gemini Notebook. But I did do that. It's now able to work through and actually help me from the actual written articles to go ahead and work up the slides. So I'm using it now. It's actually fairly decent. We'll see if I stick with it or not. But otherwise, check back with us next week. We'll talk about other things that happened in the area of current federal tax developments.